Justices of Appeal, Judges and Masters of the Eastern Caribbean Supreme Court, Her Excellency Dame Cecile La Grenade, Governor General of Grenada, and Their Excellencies, Governors, Governors General, and Heads of State of each of the Organization of Eastern Caribbean States, Member States, and Territories. The Honorable Dickon Mitchell, Prime Minister of Grenada, and heads of government of each of the other OECS member states and territories. Retired judges of the Eastern Caribbean Supreme Court, members of the Judicial and Legal Services Commission, Honorable Claudette Joseph, Attorney General and Minister of Legal Affairs, Labor and Consumer Affairs of Grenada. Honorable Garth Wilkin, Attorney General and Minister of Justice and Legal Affairs of St. Kitts and Nevis, and Honorable Attorneys General of each of the other OECS member states and territories. Honorable Ministers of Government of Grenada and Honorable Ministers of Government of each of the other OECS member states and territories. Her Honor, Madam Francine Foster, Chief Magistrate Acting, and Magistrates of Grenada, and Chief and Senior Magistrates and Magistrates of each of the other OECS member states and territories. Honorable Leo Cato, Speaker of the Grenada House of Assembly, and Honorable Speakers of the Houses of the Assembly and Presidents of the Senate of each of the other OECS member states and territories. Honorable Dr. Keith Mitchell, Leader of the Opposition in Grenada, and leaders of the opposition of each of the other OECS member states and territories. Members of the Grenada House of Assembly and members of the Houses of Assembly and Parliaments of each of the other OECS member states and territories. His Excellency, Dr. Didicus Jules, Director General of the OECS Commission. Mr. Christopher Nelson, KC, Director of Public Prosecutions of Grenada. Ms. Sigilla McDowell, Director of Public Prosecutions of St. Vincent and the Grenadines, and other directors of public prosecutions of each of the OECS member states and territories. Ms. Siobhan Spencer Joseph, Solicitor General of Grenada and Solicitors General of each of the OECS member states and territories. Mrs. Michelle John Thibbles, Chief Registrar, and Ms. Danelia Chambers, Deputy Chief Registrar of the Eastern Caribbean Supreme Court. Ms. Zaimara Forsyth, Registrar of the High Court of Justice, Grenada, and registrars, deputy and assistant registrars of the High Court of each of the OECS member states and territories. Mr. Gregory Gerard, Court Administrator, and Mr. Francis Letang, Deputy Court Administrator of the Court's headquarters, and Court Administrators of each of the High Court offices of the OECS member states and territories. Ms. Jean Dyer, President of the OECS Bar Association. Mr. Francis Paul, President of the Grenada Bar Association. Ms. Diana Thomas Hunt, President of the St. Lucia Bar Association, and Presidents of the constituent bar associations of each of the other OECS member states and territories. Learned members of the Inner Bar and Outer Bar of each of the OECS member states and territories, members of the clergy, members of the diplomatic corps, Mr. Don McKenzie, Acting Commissioner of Police and Police Officers of Grenada, and Commissioners of Police and Police Officers of each of the other OECS member states and territories, Superintendent of Prisons of Anguilla and Directors, Heads of Correctional Facilities, Superintendent of Prisons of the State of Grenada, and Directors, Heads of Correctional Facilities in each of the other member states and territories, staff of the court's headquarters and court offices in each of the OECS member states and territories, distinguished guests, members of the media, students who are with us from the various schools in Grenada today, citizens and residents of the Eastern Caribbean. Good morning. On 12 momentous occasions, I have appeared before you for the opening of the law year to bring you greetings and reflect on the challenges and achievements of the Eastern Caribbean Supreme Court we call the ECSC. It is with no less humility, pleasure, or honor than I had on each of those occasions that I address you now for the ceremonial opening of the law year 2024. My final address to you as your Chief Justice. I am heartened to have yet another opportunity to welcome each and every one of you to our customary special sitting and to wish you all a happy new year filled with promise and the hope that God will bestow his richest blessings, wisdom, and guidance upon us all and upon all the member states and territories. And to this end, we are grateful for the heartwarming and enlightening homily by Father Rumick this morning. We thank him for the service and reminding us of the balance between justice and mercy. We are truly blessed to be once again united to continue our tradition of hosting this highly anticipated event. Last year, as we eased out of the COVID-19 pandemic, we adopted a blended approach to the ceremony, with some speakers being physically present, while others appeared virtually. This year, a greater number of us are physically present as a greater sense of normalcy returns. On this occasion, it is especially pleasing that representatives from all member states and territories are gathered here in the beautiful Spice Isle, Grenada, a first. Also, as is now customary, this year's address is being streamed live on YouTube, the court's website, and the Government Information Services websites of the various member states and territories. These innovative tools and platforms allow us to reach as many people as possible, from as many places as possible. Since its inception, the Eastern Caribbean Supreme Court has been on a steady trajectory of improving the role it plays in justice administration. Collectively, we have persevered through many challenges, adapting where necessary, and reimagining where possible. Throughout the course of our journey, we have made significant strides and celebrated numerous momentous accomplishments in our tireless pursuit of our foremost mandate, which is to facilitate access to a system of justice that is accountable and independent. This mission is an ongoing one, and I do not regard it as a destination or final stop to which we may someday arrive. Indeed, it is perpetually moving the goalposts, which keep us exploring modern and transformative means of delivering justice and court excellence in a constantly changing society. As civilization evolves, so does the concept of justice. We then become more and more aware that justice is not a homogeneous notion, and that the modernization of our different social institutions necessitates new perspectives and modifications to make the justice system more accessible, inclusive, and contemporary. This brings me to the theme for this year's ceremonial opening of the law year: Innovation and Justice Reform, the ECSC looking to the future. Innovation and reform make up the mortar that connects and binds the building blocks of the justice system. Whether it is modernizing the technological resources to remedy systemic impediments to the administration of justice, reimagining processes and revising rules of procedure for greater security and efficiency, or optimizing cross-institutional cooperation within the justice system, innovation and reform are necessary tools in realizing a more fair and just society and fulfilling the court's mission. These bridge the gap between justice itself and the contemporary effectiveness and efficiency with which it is delivered. The ECSC has always remained committed to expanding and improving its processes and rules of procedure to enhance access to justice for the people of the Eastern Caribbean. Being the judicial arm of government, the court's main purpose includes upholding the rule of law and enforcing each citizen's right to equal protection of the law. Fulfilling that mandate, however, requires that we not only espouse these principles in our determination of cases which come before the court, but that we also adequately facilitate equal access to and easier navigation of the court's systems by combating structural and systemic deficiencies. But where are we now in our plan to achieve this? And what are the benefits, challenges, and opportunities that have emerged from our efforts thus far? It is crucial that in the course of our journey to procedural and technological transformation, we pause to remind ourselves of our mission and to take stock of how far we have actually come in achieving it. And so I go now to innovation. The Eastern Caribbean Supreme Court has always been committed to exploring and adopting innovations that elevate its effectiveness within the wider justice system, sometimes by choice and sometimes driven by necessity. In pursuit of our transformation, the court has relied heavily on information and communication technologies and has incrementally increased its use of technological advancements to make more appropriate and efficient use of our resources. Since 2018, we have made tremendous strides in transforming the court's filing and case management systems through our e-litigation portal, which we call the ELP. We cannot deny the very tangible benefits that we have seen since implementing the ELP. Significantly, we have experienced a reduction in delays caused by our former reliance on a paper-based system, a marked increase in the clearance rates, the greater ease in accessing and managing case files across the length and breadth of our member states and territories, allowing the court to enjoy greater ease and flexibility of operation. I am informed that here in Grenada, case backlog for civil matters has been significantly reduced. This is a feat that ought to be emulated by the other member states and territories. But what I ask is that for a more in-depth look at the court's performance, I again invite you to visit the court's website, to browse through the court's annual report, which is published there. Browse through even earlier reports in order to gain a fuller appreciation of the impact of the ELP on the court's services. The world around us is rapidly changing, and we must continuously keep our eyes on the future of technology to keep pace with the shifts in what constitutes efficient justice administration. I dare say that one of the greatest advantages of adopting a digitized case management system was most keenly felt during the crisis of the COVID-19 pandemic. Having access to an electronic means of filing and managing cases was truly instrumental in preventing a near certain crippling of the court's services during a time when being in close physical proximity was a danger to us all. Crises also produce opportunities. What courts around the world witnessed and embraced could only be referred to as a court technology revolution. The increased integration of modern technological applications into our day-to-day processes has not only made us more efficient, but has also adequately equipped us for effective crisis management. Thus far, the court has successfully implemented the ELP for the electronic filing and management of all appeal matters, civil matters in the high courts, and most of the magistracy, mainly in respect of civil and family matters, including the 3 family courts. In the magistracy, the ELP was first implemented in the family division in the state of Antigua and Barbuda in October of 2022. In July 2023, we completed the ELP links for family and civil matters in the magistracy across all member states and territories. This has allowed the e-filing and management of the current family and related domestic case types, even in cases commenced before implementing the ELP. These cases can now be digitally managed in a manner which enhances case flow, searchability, and importantly, storage and retrievability. Feedback for enhancing the operations of the system has been taken on board as it relates to the ease of payment facilities for child maintenance payments and the like. These enhancements are in progress. We have also made great progress toward realizing the launch of the criminal module in both the high courts and the magistracy across the member states and territories. The implementation of the criminal module will take us to a full digitization of case management services in all cases and at all levels of our court. A novel feature of our electronic case management system, which is being pursued, is the adoption of a cross-sectional approach by automating information sharing between the various stakeholders in the management of criminal cases. Prospective users of the criminal module will include staff from the offices of the Directors of Public Prosecutions and Attorneys General. Later, it is hoped that this will be expanded to the police and correctional facilities. It is expected that the sharing of information across agencies and the introduction of an automated data exchange system will reduce the inaccuracies and delays often caused by paper-based methods in criminal case management, facilitate ease of cross-institutional processes, and allow for the reallocation of human resources to other important tasks for greater efficiency. I am pleased to say that the criminal module of the ELP is nearing completion for full implementation, with testing for full functionality currently underway. I am reliably informed and therefore proud to announce that the first installation of the criminal module is on schedule to go live during the first quarter of this year, with a complete rollout across all member states and territories by the third quarter of this year. I should also inform you that the court has been actively engaged in sourcing and implementing electronic jury management software to complement this system. Registrars have been given a demonstration, and their feedback has been positive. Such a system will reduce many of the tasks which are currently performed manually, reducing the subjectivity of the process which may creep in, while enhancing efficiency in the overall jury management process. I must at this juncture also say how elated I am by the launch of the PACE Justice Project by our European Union and UNDP donor partners, which will be assisting at least 4 of our states, namely Antigua and Barbuda, Dominica, St. Lucia, and St. Kitts and Nevis, in implementing various measures such as digitization and electronic interoperability among state institutions, aimed at criminal backlog reduction in our region. The court is poised to attract assistance from other donor agencies in the quest for digitization in all aspects of court operations across all member states and territories. It is my fervent hope that in the not-too-distant future, the court's digitization journey will be fully realized as its ICT push continues. In this era, no court can operate effectively and efficiently without using ICT tools to deliver justice. To think or do otherwise will simply be retrogression. Technological advancements must remain one of the court's top priorities for improving justice administration in our region, which is a critical component for the economic sustainability of our small island states and territories. In keeping with our ongoing efforts to improve our technological resources, the Eastern Caribbean Supreme Court in May of 2023 also launched a completely new version of its website. The court's IT team took on board much of the feedback received from the users of the site. Users should now have a more enhanced experience from the version which was in use since 2011. Searching the judgments database, which now exceeds 10,000 entries and growing, is now considerably easier, we hope, with additional parameters to allow users to access the information which they wish to retrieve more easily. Ways for enhancing the look and feel of the website are continuously being explored. Your constructive feedback is invaluable, so keep it flowing. As the court continues its ICT push, there is the opportunity to think about and plan ahead for other technological innovations from which the court may benefit. One such technology that immediately comes to mind is artificial intelligence, more popularly referred to as AI. AI entered the global mainstream generating its own seismic event in 2023. It appears to be as powerful as it is fascinating, with the ability to accomplish feats beyond our imagination. I am sure it is not lost on any of us the divergent views emerging from the use of AI in the legal profession. It sparks interest and anticipation in the younger and more technologically savvy generation of the legal profession, while invoking the cautious trepidation of those who are more seasoned and traditional among us. There is no doubt that AI has opened an entirely new vista with the promise of a vast range of new benefits, but which will also bring about new challenges for courts and the legal profession. For example, the courts will have to grapple with questions of what is real or authentic, or from authentic sources in areas of evidence, as well as the law itself. It has also evoked a considerable degree of fear, and discussions abound about the potential to render humans extinct. Make no mistake, AI is here to stay. What we at the Eastern Caribbean Supreme Court cannot do is to ignore either the benefits or dangers of AI, which is developing at lightning speed and being integrated in every aspect of our daily lives. What I would say to you, though, is that as in all things, balance is key. We must evaluate and take advantage of the forms of AI that will assist us in overcoming the various challenges we face in making the court's processes more streamlined and efficient. New technologies like AI allow us to automate highly repetitive and routine tasks. Some useful implementations of this innovation include automated court schedules, virtual customer service agents, automated document sorting and review, and computerized report generation from applications like our ELP to provide real-time statistics for more effective management and evaluation of our key performance indicators. At the same time, judges must become aware of how to manage and evaluate AI-generated material. This brings me to a resource issue that requires our immediate attention: the speed and quality of transcription services. This ongoing challenge has affected the court on an institutional and service-based level for years. Currently, the various registries and courtrooms across the member states and territories must contend with infrastructural deficits and other inconveniences, such as the unfortunate proximity of courtrooms to noisy, busy streets and poor acoustics in the courtroom, which negatively impact the quality of the audio recordings of hearings, or in some member states and territories, not having courtrooms at all. These deficits have plagued the courts with negative consequences on the administration of justice. The use of AI-driven automatic transcript generation could assist us greatly in resolving some of these obstacles. Advanced ICT tools using AI can produce transcripts in real time with over 90% accuracy. If our court, including the magistracy, was in a position to put in place this type of technology, it would reduce the serious delays we face in transcript production, which is currently being done manually, and at no time with enough transcriptionists to carry out the tasks. These are impediments that, if removed, would enhance access to and the efficient delivery of justice in our region. The lack of or the slow production of transcripts adversely affects the lives of our people, those who have caused harm, loss, or other detriment, and those who have suffered harm, loss, or other detriment. The adoption of innovations like AI would assist in mitigating these challenges. That said, these innovations cannot happen without much needed improvements to the court's infrastructure and technological hardware. Without purpose-built, sound-controlled courtrooms that are adequately outfitted with quality audio recording equipment, the process of transcript production using AI would remain simply a wish. A low point in my tenure as Chief Justice, spanning over a decade, has been the abysmal lack of progress by the governments in providing proper court facilities which would enable the judicial branch, a co-equal branch no less, to fulfill its mandate to the people of this sub-region. A ray of hope is emerging. It seems that the state of St. Lucia is now poised to commence shortly the construction of proper halls of justice, and the court's headquarters, including the Court of Appeal, will soon be housed in more modern facilities. However, as I have done over all the years, I call upon the governments across the Organization of Eastern Caribbean States to undertake its responsibility and build fit-for-purpose courtroom facilities that are conducive to the judiciary's work so that it may more effectively execute its role as the gatekeeper of the rule of law within our societies. The reduction of delays and ultimately the backlog of cases before the court depends heavily on the financial support the court receives from the various governments. Publicly laying blame at the court for delays without asking the hard question about what resources have been provided to enable proper and efficient functioning of the court's system is, in my view, disingenuous, with the consequence of undermining the very justice system to which we must all look for the protection and vindication of our rights and for promoting a peaceful state of existence. It is past time for turning words into deeds and truly accept that real investment in the judicial branch, in all aspects of its work, is an investment in our society and our countries overall. Justice reform. While the court's incorporation of emerging technologies and modern thinking has indeed positioned it to be more accessible and effective, those innovations cannot operate in a vacuum. It is important that we complement them with structural and procedural reform initiatives to fully realize their benefits. Last year, I announced that concurrent with our ICT push, the ECSC had finally established the Long Family Division in Antigua and Barbuda. The 17th of July, 2023 marked 1 full year of the existence of the Family Division pilot project there. Measurement of the effectiveness of our court reform initiatives has required us to carefully monitor and evaluate much of the court's activities in a manner consistent with modern administrative practices. The committee overseeing the implementation of the Family Division has been tasked with conducting a full review of the practical application of the Family Proceedings Rules 2022 from the perspective of the lawyers who have the most day-to-day experience working with these rules. The committee was also asked to examine what, if any, other legislative support would be required to allow for a more holistic functioning of the family division, in particular as it relates to the operations of the magistrates' court within that division and the gateways needed for a smooth transition between the magistracy and the High Court, in keeping with the vision of a one-stop hall for all things family. This review is ongoing with the hope that a more integrated and streamlined approach will result in the future, leading to the improved ease of access and efficiency in operation from origination to completion of the process and enforcement. As with any reform, the hope is that the continuous valuation will occur for measuring whether the objectives are being met. One core objective is to bridge the divide between the court's available processes and the remedies it provides to ensure timely and effective relief in family and other domestic matters, particularly those that involve more vulnerable groups like children. The Eastern Caribbean Supreme Court has also embarked on developing model criminal procedure rules to govern the practice and procedure of the criminal divisions across the 9 member states and territories. You may recall that St. Lucia promulgated criminal procedure rules in 2008, while St. Kitts and Nevis and the Territory of the Virgin Islands embarked on the preparation of draft rules which are not yet in force. In March 2023, I took the step of establishing a criminal procedure rules committee tasked with drafting model criminal procedure rules to be promulgated pursuant to the empowering provisions under the Supreme Court order. Culling from international best practices, the aim of this is to create a harmonized and comprehensive set of rules which will act as the foundation on which to build out other criminal court reforms for supporting robust case management, improved time standards, certainty, transparency, and equity in the criminal justice system. This, hopefully, should build public confidence in the justice system. I take this opportunity to thank the members of the Criminal Procedure Rules Committee, being co-chaired by Justices of Appeal Price Findley and Ward, and for undertaking this task. I know that they are working assiduously toward this end, and I am confident that they will complete this task in quick time. That said, the current picture of our criminal justice system is disheartening. Data shows high levels of remand populations at our prisons and correctional facilities, in some cases as high as 70%, and for lengthy periods. This reflects a criminal justice system which is clearly bogged down at virtually every stage of the criminal process, from charging and prosecuting to trial and disposition, for a variety of reasons, with the bottom line being, in the main, inadequate or lack of resources. Let me be clear. The courts are but one part of the equation. The issues creating this unhealthy state of affairs are multi-sectoral and require an all-hands-on-deck approach to resolve it, ranging from proper and timely police investigations to timely prosecutions, trials, and other measures leading to timely dispositions. I therefore call on all stakeholders, including the courts, to tackle this issue as a priority lest irremediable damage to the criminal justice system occurs with damaging consequences for us all as a people. A bright beam in the court's reform efforts in 2023 was the long-awaited completion of the revision of the civil procedure rules. As I am sure you're all aware, the Civil Procedure Rules Revised Edition 2023 was finally launched and came into effect on the 31st of July 2023. The new amendments to the rules are expected to modernize and further streamline civil practice and procedure across the 9 member states and territories by revising and incorporating provisions that further support our current legal and technological environment. Notable revisions and additions to the new rules include advancements in alternative dispute resolution mechanisms by the introduction of Judicial Settlement Conference, or JSCs, as we call them. Judicial settlement conferences complement the court's mediation program. They were first introduced in the Commonwealth of Dominica as a pilot and were met with considerable success. It has been hailed as a positive step by stakeholders across the member states and territories. This tool should contribute significantly to reducing the court's case backlog, and I urge legal practitioners and litigants alike to take advantage of it. Another key addition is the integration of the e-litigation filing and service procedure rules into the new civil procedure rules. With other revisions in mind, such as the removal of the requirements to seek leave to apply for judicial review and to serve proceedings outside of the jurisdiction, I have no doubt that the Civil Procedure Rules 2023 will stimulate further developments in Eastern Caribbean jurisprudence. On Monday, the 15th of January this year, 3 new practice directions will take effect. They will guide the practice relating to pre-action protocols, interim remedies, and civil restraint orders. A new practice direction dealing with detailed cost assessment will be introduced shortly. Therefore, I urge all legal practitioners to adequately apprise themselves of the new rules and practice directions so that the practical benefits of this revision project are realized. I also take this opportunity to once more applaud and thank the Civil Procedure Rules Committee, the teams from the Impact Justice Project, and the Legislative Drafting Unit in Antigua and Barbuda, and all others not specifically mentioned who toiled dutifully to conclude the publication of the new rules, thereby ensuring that the court accomplished yet another milestone in the fulfillment of its mandate of improving the administration of justice in the Eastern Caribbean. Capacity building and judicial education. In tandem with structural and procedural reform, the court's capacity building initiatives are also crucial to creating a just and proportionate justice system. These strategies, which include the court's judicial education conferences and mediation training workshops, provide the court with the opportunity to better equip judicial officers, court staff, legal professionals, and court users with the requisite knowledge to make the court's processes more effective and accessible. As part of the court's efforts to improve judicial efficiency and build capacity, the Judicial Education Institute successfully hosted the annual Judicial Conference in March 2023. The conference was attended by judicial officers from all the member states and territories. One component of the conference featured an orientation program for newly appointed judicial officers. Another component was the sensitization of judicial officers, including registrars, to the amendments in the Civil Procedure Rules 2023. There were also robust discussions on various topics, including commercial litigation. Registrars also learned skills and techniques for improving court management, ethics, case management, data quality control, and other soft skills. This was then followed up with an intense case management training program for judges in June of 2023 in St. Lucia, where issues concerning procedural justice and the Eastern Caribbean Supreme Court's performance in case management efficiency were reviewed and effective case management strategies canvassed. The final event on the JEI calendar for 2023 was the Magistrates' Conference held in October. This conference focused on several aspects of the magistracy, which were targeted to promote greater efficiency. These included leadership and case management, the importance of data in performance measurement, developing self-awareness and self-management of personal emotions, utilizing and understanding the sentencing guidelines, and framing sentencing decisions, warrants and arrest, and preparation of appeals. It is expected that the Judicial Education Institute, in keeping with its mandate of continuous capacity building as a complement to judicial reform, will continue its training programs in 2024. Permit me to place on record my debt of gratitude to the outgoing chair of JEI, Justice of Appeal Gertel Thom, who took on the mantle and steered it so ably over the years. I now turn to mediation. A staple in the court's capacity building initiatives is the JEI UWI mediation training workshops, which I am happy to report finally resumed in-person sessions here in the Spice Isle in March of 2023. We are grateful to the Judicial Reform and Institutional Strengthening Jurist Project, which facilitated this training. On behalf of the Eastern Caribbean Supreme Court, I thank the Jurist Project and the Canadian government for its continued partnership in delivering impactful programs which have left an indelible mark on the improvement of our justice system. This affords a useful point for apprising you of the Criminal Mediation Initiative, which is well underway for the implementation of criminal mediation across the member states and territories. This initiative is aimed at reducing criminal backlogs, mainly at the level of the magistracy, while at the same time incorporating alternative sentencing measures, restorative justice practices, and other approaches which can further enhance the delivery of criminal justice and also go a long way toward rehabilitating young offenders. Measures aimed at rebuilding lives and livelihoods where possible generate a more lasting and positive impact than punitive measures ever could in terms of giving hope and repairing relationships, which can ultimately redound to the enjoyment of safer and more peaceful societies. The Criminal Mediation Committee, under the chairmanship of Justice of Appeal Ellis, is hard at work on this initiative, and draft rules and practice directions are nearing completion for consultation and rollout. All stakeholders, including the governments, should lend their full support to this initiative, which should aid in tackling not only criminal backlog reduction, but also help to reduce recidivism and provide meaningful pathways for young offenders to become productive members of society. Of note is that the National Mediation Committee of Antigua and Barbuda hosted its second annual Mediation Symposium and Mediation Awards on Thursday, the 27th of April 2023, at the High Court of Justice in St. John's, Antigua, under the theme, Restorative Justice, Introducing Mediation in Criminal Proceedings. The symposium was attended by more than 200 persons, virtually and in person, and explored the application of restorative justice mechanisms to the criminal justice system, particularly criminal mediation. Apart from the inclusion of mediation awards at that symposium, the Mediation Committee also showcased a very powerful educational video exhorting young people to embrace mediation rather than escalate disputes into acts of violence with potentially disastrous consequences for everyone. It is a video that I hope gets airtime on every radio and television station without a fee, as part of our civic duty to encourage peaceful dispute resolution. Despite setbacks, I am also pleased to report that a National Mediation Committee for St. Vincent and the Grenadines has made progress and is now housed in appropriate facilities conducive to facilitating amicable negotiations between parties. This, in no small measure, was made possible through the kind support and sponsorship of the Jurist Project. Again, I thank the Canadian government through the Jurist Project for their transformative impact on mediation in St. Vincent and the Grenadines. Continuing over the years, the court has prioritized mediation promotion throughout the member states and territories by engaging and facilitating various forms of mediation campaigns. These steps help to spread the word in the schools and in the wider community within our subregion and farther afield. Also, these steps, though small, will have a huge lasting impact over time. This work, in my view, despite resource constraints, must continue. Sustainable social transformation for a fairer and more just society requires social justice strategies that promote restorative behavior. However, the court cannot do it alone. The court needs greater support from our social work agencies to provide therapeutic interventions, such as programs that target anger management, conflict resolution, peer mediation, parenting support, and mentorship. This support would go a long way toward complementing the work of the court for more impactful justice administration. It is now time to welcome our new judicial appointees and to bid farewell to those who are no longer with us. It is John C. Maxwell who said, "Change is inevitable, growth is optional." Indisputably, over the years, the court has had to adapt to changes and has, with these changes, sought to embrace continued growth. Permit me, therefore, to welcome the most recent appointees to the bench of the Court of Appeal. His Lordship, the Honorable Eddie Ventus, who was appointed as a Justice of Appeal, and Her Ladyship, the Honorable Vivian Georges Taylor Alexander, who was appointed to act as a Justice of Appeal effective the 8th of January 2024. I also welcome the most recent appointees to the bench of the High Court. Her Ladyship, the Honorable Sonia Young, His Lordship, the Honorable Ricky Burnett, His Lordship, the Honorable Renee Williams, and His Lordship, the Honorable Alvin Pariak Singh, as well as their Lordships, the Honorable Tunde Bakre, the Honorable Dale Fitzpatrick, the Honorable Paul Webster, the Honorable Richard Floyd, and Her Ladyship, the Honorable Racken Brown, who were appointed to act as judges of the High Court for various terms during this year. I also extend a warm welcome to Master Sybil Snack Dantes, who was appointed as Master of the High Court in February 2023. I wish them all a successful tenure on the bench of the Eastern Caribbean Supreme Court. I would also like to extend my gratitude to all those who assisted the court last year by answering the call for brief acting judicial appointments. In the last year, we bade farewell to His Lordship, the Honorable Paul Webster, as a Justice of Appeal, having retired in August of last year. Between 2001 and 2015, Justice of Appeal Webster undertook several temporary appointments as a judge of the High Court and the Court of Appeal, serving on a longer-term basis as a Justice of Appeal. His invaluable contributions to the court will forever be etched in the annals of our court's history. I express my immense gratitude for his years of dedicated service to the court, which he extends to us still by acting as a commercial judge in the Virgin Islands. As recent as last month, on the 21st of December, 2023, we bade farewell to Justice of Appeal Thom. She was a stalwart on the Court of Appeal, and indeed in so many areas of the court's work that time does not permit me to address here. Suffice it to say that her contributions as a member of the Judicial and Legal Services Commission, as chair of the JEI, member of the inaugural Sentencing Guidelines Committee, the Criminal Mediation Committee, and the Family Proceedings Rules Committee speak volumes in respect of the critical support she gave to me as Chief Justice and the depth and breadth of her dedication and commitment to the court. Words, in my view, are insufficient to express the magnitude of our appreciation. She can only be described as a true servant of the people. In March 2023, we also wished a happy retirement to Her Ladyship, the Honorable Victoria Charles Clark, who served as a High Court judge since September 2016. I take this opportunity to wish her every success in her future pursuits. Permit me now to recognize and reflect on the unfortunate passing of retired Justice of Appeal, the Honorable Olame Edwards, in November 2023. The Honorable Justices Stanley Moore in March 2023. The Honorable Claire Henry in June 2023. The Honorable Monica Joseph in July 2023. And the Honorable Dunbar Snack in September of 2023. The court suffered many losses in 2023. We are grateful to them for their stalwart service, and together with their families, we mourn their loss and extend our deepest condolences. Loss reminds us to be thankful, and so at this juncture, I now place on record my gratitude to all those who have helped propel the court forward and who continue to display their unwavering commitment to its future success. To the dedicated judicial officers of this court, magistrates included, I thank you for your diligence and faithful service. I urge you to continue to serve at your best. I also extend my gratitude to the registrars and their support staff at both the court's headquarters and the constituent court offices of the member states and territories. I applaud your teamwork and earnest efforts which keep the Eastern Caribbean Supreme Court in steadfast pursuit of its mission. To the OECS Bar Association and the constituent bar associations of the Eastern Caribbean, in extending my thanks to you, I would also remind you that your keen collaboration with the judiciary is important for the advancement of the legal profession and the administration of justice. We thank you for the important work that you do, and I would also urge that you continue all the good work that you do in supporting the Eastern Caribbean Supreme Court. I would like also to recognize our external partners, stakeholders, and donor agencies who have worked with us and given us much needed assistance to expand our capacity. On behalf of the judiciary, I express our heartfelt gratitude to the Government of Canada for the Jurist and Impact Justice projects, the United States Embassy, the British High Commission, UNICEF, UN Women, UNDP, USAID, the University of the West Indies, and indeed the governments of the 9 member states and territories for their support. The court's lack of financial autonomy means that your contributions are vital to its continued development and success in fulfilling its mandate. Therefore, we thank you for your partnership and look forward to its continuation. I wish to extend thanks to the OECS Commission and to all those who are not specifically mentioned, but who nonetheless have played an instrumental part in the court's success in 2023. Finally, my sincere thanks and appreciation to all the judicial officers, registrars, and speakers, some of whom traveled here to attend this special year's sitting. I am informed by my brother, Justice of Appeal Michel, that we have an entire complement of about 22 judges here at this opening ceremony of the court's Your Lawyer, and I think it is something which is truly special. It, in my view, demonstrates their support and commitment to the Eastern Caribbean Supreme Court. As I close my final lawyer address, may I say that it has been my greatest privilege to serve you as your Chief Justice. Reflecting on the last 11.5 years brings forth in me mixed emotions. It feels like a lifetime. It feels like a day. We grappled with many challenges, but we faced them together, head on. Many sacrifices have been made, but the rewards of serving in this office have been far greater. As I exit the stage, it is my hope that the court is a little bit better than when I entered. My fervent hope for the future is that the Almighty God, who has seen this court through all its challenges and who has blessed all its successes so far, will show it journeying mercies on the road ahead. The Eastern Caribbean Supreme Court's future will no doubt continue to be laden with obstacles, but more importantly, it will be ripe with opportunities. We need only to persevere with courage and resilience and pray that the Almighty will see us through. And so I thank you all for the support you have given me over the years. I wish especially to thank the helpful and dedicated staff at the court's headquarters and indeed at the various court offices across the 9 member states and territories, who made anything that I was able to achieve during my tenure possible while making it seem easy. It isn't easy work. They simply make it that way and therefore make my job that much easier. I will carry and cherish the memories of our time and the work we have done together always. It has truly, truly been an honor serving you. I thank you.